now. Okay, hello all of our Colby Sawyer International students. Welcome, we're happy to have you here. And we're also happy to welcome Crystal Malik from McCandlish-Holten law firm. She's gonna kind of go over with us all of the ins and outs of securing employment for international students after graduation. During the Zoom, please feel free to ask questions. I think the best way to do that would be through chat. And I think I have enabled chat for everybody. Yes. So please send any questions through chat. Keep yourselves muted, please, just so we don't have any background noise to interfere. And I will be kind of doling out those questions as we see fit. We will also have time afterwards for a question and answer session if there's any last minute questions that you have. But I'm going to go ahead and let Crystal take it away.
Hello, everybody. I'm Crystal Malik. I'm an immigration attorney at McCandlish-Holten in Richmond, Virginia. We do these talks all over the country for students, just trying to kind of give you an idea of the work options that are available to you while you're in school, after you leave school, both temporary options, and then also the options for green cards, if that is a goal of yours in the future, if you would like to stay in the United States permanently. So what I'm going to do is I'm going to spend a little bit of time going through each little step. I'll stop and ask for questions, periodically. We'll also be monitoring the chat just to see if you all have compiled some questions while we go. If you think it's something you're going to forget, definitely stick it in the chat. If it's something that's a little bit more personal, you might want to write down this email address and you can kind of email me after so that you don't have to, put all of your information out there. This is more for kind of general questions about more very specific personal things would probably be better outside of this chat. All right. So my understanding is everybody I'm talking to today is probably an F1 student. The J1 program works pretty similarly to the F1 program. Both of these are handled in CVES. People at universities, students, and researchers and such can be in both different types of status. The J1 status is actually something that you could use as an option for work authorization after you've graduated and after you've done your OPT, your optional practical training after graduation. So it's another option in your path that's out there for you. It's important to note that everything that I talk about today has dependent options. So if you are married, or if you have children that are under the age of 21, all of the visa options that I'm going to talk about would allow you to bring your dependents with you. So as a student, you're allowed to do that. If you were to get an H-1B visa or an L visa later, those options all allow you to bring a dependent. It's the same thing for the green card process. So if an employer ever sponsors you for a green card, you're allowed to bring dependents, but it specifically is spouse or children under the age of 20. So that's just something to keep in mind as we go through this little section here. The first work option that we'll discuss is the pre-graduation work options. And these are all pretty much options that you're going to have to go through your designated school official, your DSO for. My understanding is at Colby Sawyer, that's your registrar's office, and they handle these types of requests. They give you all of your policies and procedures for these, and they help you if you have to apply for one of these. So the first type of employment that is allowed for pretty much everybody is on-campus employment. These are for student services options, typically 20 hours or less a semester or 20 hours less a week that you're allowed to work on campus, even as a student. Aside from that one work option that's open to students, they have the option for curricular practical training, which is something you would use as a student if you had an internship that you needed to complete at your university, something that was integral to your program. So something, let's say you're a business student, and as a business student, you're required to complete a semester internship that's related to your major. You would need to go through your designated school official, and they would need to authorize that employment through CVES. They would have all sorts of paperwork requirements that you had to fill in order to do that through your department and through your designated school official, and they would authorize that in CVES. They would authorize specifically who you were going to work for, where you were going to work for them, and what dates you're authorized to work. And it's super important to understand that these have to be specific dates. So if your authorization ends on December 25th, of a certain year, you can't work past that. You're only allowed to work within the confines of the authorization that's on your Form I-20 that your DSO gives you. The next option is optional practical training, which everyone who completes a new degree level is authorized to have as long as they've had 12 months of studies and they're in F1 status. So each degree level allows you a new period of 12 months of optional practical training upon graduation. What you do there is you also have to work through your DSO's office. You have to get an authorization to file that application. You have to have an I-20 issued, a new one that authorizes the optional practical training application, and then you have to actually apply through USCIS for that work authorization. The other options that you see below, there's an economic hardship type of application, also has to go through your designated school official, has to go through U.S. Citizenship and Immigration Services. And this is for extreme situations where there's a financial need that you did not expect when you came to the United States as an F1 student. The government has designated several countries who have crises that are ongoing as countries where you would have to put very little information forth to get this type of work authorization because there's an unknown extenuating circumstance for that country. Your DSO would have more information about that and would be able to help guide you through that type of application. Designated international organizations, let's say you're a business student and you want to go work for the IMF, that's a designated by regulation international organization where you could apply again for work authorization through their sponsorship. Again, you would have to talk to your DSO because you're in school and everything has to go through your CVIS record, but that's a type of work authorization that's available to you. The question that we get the most often of any question from students is whether or not you can do volunteer work. There's this misconception that if you're not being paid for working, then it's not work that has to be authorized. And that's just not true. The line is productive work. It's not the payment. So it's super important that if you get an offer for an internship, that you see if you can go ahead and, even if it's an unpaid internship, you need to work through your DSO's office to get that authorized, that work authorized. It's very, very unlikely that you're going to have an opportunity through your education that would be able to be undertaken without that authorization. The line for volunteer work is a true volunteer organization. So let's say that there's an animal shelter in the neighborhood that doesn't ever pay any of their volunteers and you're going there to help with the animals, right? That's something that you could probably be able to do as a volunteer, but that's not something that most people are asking us about, right? They're trying to do something that's related to their major and get experience. Those are all opportunities that are going to have to be authorized. Very important not to try to undertake these without talking to your DSO. So the next step is trying to find post-graduation employment. It's really important to understand that we understand that it's really hard for every student who's trying to find a job after graduation, but you have this extra added little hurdle of trying to make sure that you can explain to your employer how they can hire you, how they can employ you, and how they can get you authorized to work. Once you have that knowledge and the ability to kind of describe it to your employer, they really want to hire international students. International students typically have skills that these employers are really, really looking for, whether that be linguistic skills or social skills or just a knowledge of the world that not every student is going to have because you have that international experience, right? That international living experience that maybe they don't have in any of their other candidates. The problem is that it's going to be up to you a lot of the time to be able to explain to employers or to convince them that it is an undertaking that they can do. The screen that I have up now is the typical path for international students. So if you're an international student, you're probably in F1 status. Once you graduate, you'll be eligible for that 12 months of optional practical training. If you happen to be a STEM student, then there's an additional 24 months of academic training of work authorization that is open to you, STEM being the science, technology, engineering, and math majors. If you've already used up your 12 months, then we go down to the next thing on our list, That could be a J1 academic training experience. Let's say that you're a researcher and you wanted to work doing that, or if you had a company that wanted to sponsor you for J1 through academic training, or H1B. H1B is the more desirable of the two, but there are complications with getting H1Bs because so many people want them. The academic training is 18 or 36 months, depending on the type of program that you've been accepted to. H1B lasts for 6 full years. And that's the classification that we're going to focus the most on, is this H1B, because it is the specialty occupation visa. It's for people who have a bachelor's degree or higher and have been hired by a company in the United States to work. After that, we'll start talking more about the green card process. So the difference between the two is we have temporary versus permanent. So we're talking about permanent resident green cards, which is something that allows you to live in the United States, travel freely, back and forth, work for any employer, versus temporary non-immigrant options, which allow you to stay in the US temporarily and have varying degrees of ability to do things, right? So with temporary non-immigrant visas, every single time that you leave the United States, you have to apply for a visa to return if you don't already have a visa in your passport. So it's just like your F1, right? So each individual visa has its own rules associated with it. There are categories A through V in the alphabet, and every single one has different permissions, different rules that surround them. Not all of them allow for employment, and some of them that do allow for employment make you find a different type of employment, like make you apply for an employment authorization document separate from your visa status. We're going to focus again on this F1 or the H1B, but I've sent around a handout, I think that was emailed to you or will be at the end of this presentation, that describes a whole bunch more of the non-immigrant visa options. There's one that you have heard about that you think you qualify for that we haven't discussed, or you can check that list and see if there's information there, or you can contact us and we can try to provide more detail if you feel like there's something that you qualify for. So the biggest concerns that employers are going to have when you talk to them is cost, timing, and then what do I have to do? What is required for me to do in order to be able to do this legally? Because everybody knows that it's complicated, or they think it's complicated. So the first step, again, we talked about is optional practical training. What you see on your screen are all of the rules that surround optional practical training. When it comes time for you to apply, don't go back to this slide. You're going to go to your designated school official. You're going to get their instructions and their rules, and you're going to check what the rules are at the time that you're applying, because these could change at any moment. These are the rules as they stand now, and I want you to look at them. Look at these days, right? They have all of these day requirements. These are all hard, fast requirements, and any requirements that they put into place after these are also going to be hard, fast requirements. If you miss one of these deadlines, if you miss any of these steps, they deny the application, and there's not an appeal from that denial if this is one of the reasons that it was denied. So you have this rule about you can apply up to 90 days before completion or 60 days post. If you miss that by a single day, they deny the application. You have to apply within 30 days of OPT authorization from your DSO. If you do that outside of that deadline, if you one single day, they receive this application late or early, and they will deny the application. They've started allowing for online applications for these OPT applications, and it's a really good idea. The reason is because some of the denials that we've seen in the past, the majority of the denials that we've seen in the past are like delivery issues. Someone mails their application, but FedEx delivers it 2 days late, or the US Postal Service loses it, or it gets marked delivered, but it never actually was delivered, or it's delivered a whole week late. Those problems, those issues, those courier issues could cause your case to be denied. And then when you appeal based on somebody else's error, it's not accepted. So these online applications are really super attractive for that reason, because when you apply online through your MyUSCIS account, you know that it's accepted same day. So you can make sure that you're meeting the exact deadline and submit. Once you hit submit, it gives you a receipt number and a confirmation that it has already been submitted, and you know that you're not going to have to worry about a delivery error. The major complication we've seen with people applying on my USCIS is people who forget to ask their DSO to issue their I-20 before they file. You cannot file your optional practical training application until your DSO authorizes it. The DSO has to authorize it in CVIS. They have to issue you an I-20, and you have to attach that I-20 to your application. If you submit your application and then your DSO issues the I-20 2 days later, your application will be denied. So if you try to do this without your DSO's authorization and your DSO's help, your case will be denied. You have to go through your DSO, you have to follow their rules, you have to get their help with this application. One really great thing about this program is also that you can draft your application and then save it so that your DSO can help you in reviewing it, looking at it, making sure that it's what they want it to say. It is a printable application. It is a savable PDF. So you can easily share that with your DSO after you've drafted it. And then submit it and know that you're not going to have to worry about a delivery error or a payment error or any kind of problem like that. The 24 months, the extra 24 months have a separate set of requirements. So the great thing about this optional practical training, right, is once you get that EAD in the mail after you've applied and been approved, you can work for any employer in your major. They don't have to do anything. They don't have to sponsor it. They don't have to communicate with your school. They don't have to pay for anything. And that's a full year of work authorization where they basically get to have you on like a probationary period. You get to test them out and they get to test you out. You get to go and see if this is an employer that you're interested in working for long term, if this is a job that you enjoy, if this is a job that you like. Once you get out of this, if you're a STEM OPT, if you're a STEM graduate and you have the eligibility for the extra 24 months, there are a little bit more requirements. They still don't have to sponsor you. They still don't have to pay anything. They just have to be willing to sign a training plan that describes exactly what it is that you're going to be doing and how it relates to your major, how you're going to be trained, and how you're going to be evaluated. They have to be willing to correspond with your school, and they have to be e-verified. Now, e-verify is just an internet-based program. It's a pretty easy program to join. So if you're in your OPT and you're working for an employer who doesn't have e-verify, but you know in your mind that you're going to want to do your STEM OPT, don't ditch that employer just because they don't have e-verify, because they could decide, and many employers do decide, to join e-verify before you have to start your STEM OPT so that you can continue with that same employer that you enjoy and that they enjoy working with you. So by the time that you do your STEM OPT, they do have to be verified. While you're doing your regular OPT, they don't. And then they have these limited requirements for this 24 months of additional work authorization. They don't have any other reporting responsibilities other than the ones that you see here. They have to correspond with your designated school official. Now, keeping in mind, you'll have been graduated for 2 or 3 years at this point. If you have STEM OPT, you're still an F1 student. You're still working with your school. So it's going to be really important during this whole period, the whole period where you're doing your first 12 months of optional practical training. And if you're eligible for this extra 2, you still are responsible to contact and keep in touch with your school. They still have to know where you are. They still have to know how to contact you. And you have to update them every single time that you move employers so that they can update your CVIS record and keep everything on track. Do we have any questions so far? We're at a good point to ask some questions if you have any.
Yes, I have a question.
Awesome.
So for the OPT, you said if you're a STEM major, it's 12 months and then additional 24 months, right?
Right.
Does it have to be related? Does it have to be your major, or it can be related to your minor as well?
So it depends. Everything is dependent on the CIP code on your I-20. So if the CIP code is a designated STEM major, then you'll be allowed to get that extra STEM OPT, and it has to be related to that. You have to be able to document and explain to U.S. Citizenship and Immigration Services how the two are related. So you will check the CIP code that's on your I-20 against the STEM code list that the Department of Homeland Security publishes. And you can, it's a very easy to find Google, via Google list, where you can see those exact codes.
Okay, so it's, you said it's the major, right? It can...
So the school has a way of classifying it, and the CIP code that's on your I-20 is going to determine what it is. So if it's not incorporated into your CIP code, then it's a very easy test. Does this code match or does it not match?
Okay, thank you. And another question that I had is, we talked about CPT a little, you talked about it. Does all CPT have to be for credit, or can it also be?
So it just depends on the way that your school does it. Every school has a different set of rules around curricular practical training. I think in most cases it probably is related, but it's possible that it's just a piece of your actual class, right? Like it could just be a piece of a course. So it's not separate credit. It totally depends on your school's rules internally.
Okay, thank you.
Yeah. Any other questions so far?
I have one question.
Mhm.
So there's this rule where if you use like a certain amount of your CPT, then you're not able to qualify for the OPT part.
Right.
Can you possibly apply for like the STEM extension of the 24 months, even though
No. So
okay.
you have to be very, very careful not to use up your practical training. So if you have curricular practical training, keep it at 364 or less so that you can get that full year of optional practical training and won't lose your STEM OPT. Very, very important. You cannot apply for STEM OPT off of CPT. So if you've taken that year, you will have lost 3 years. So it's super important to keep that number down. And you can do that through using other types of work authorization within your program. Yeah.
Thank you.
Thank you. Do I have any other questions?
I have one more question, sorry. It's about CPT. So you said there is like a start date and an end date, and we can't go beyond or prior to those dates.
Right.
Does training also count in those dates?
Yes, and employers will try because they don't understand the rules and they don't understand how punitive it is to you. Like they don't understand. They just don't understand. They will try to say, oh, but it's just training. It's not a full day of work. No.
Okay.
You do not go somewhere to work if you do not have authorization for that particular day. So if you need an extra day, if they need to train you, they need to request for that date to start with. And you need to get it to your DSO so that your DSO can approve it. And if they don't get it approved in time, you don't go to work because that one day can knock you completely out of status. This is a very punitive setup. It's very important for your future to keep an eye on those dates.
And so a CPT, is there a time frame for CPT after which it starts counting as OPT, or is there like a number of hours or number of days? Or...
So I think what you're asking is how many days can you work in CPT before you don't have any more OPT,
yeah.
Right? So the limit is a year. So 365 days means that you don't have OPT. You've used all of your practical training through CPT. So you have to keep it. And I've seen DSOs actually do this where they get them up to 364 and then that keeps them eligible. I personally would be too scared to go that far if it were me as the student. But that's just because I'm very conservative about risk. Like I don't like risk. But you can do up to 364 and be fine. It's that 365th day.
So is that the CPT? I'm sorry, I'm a little confused. My question is, when you're doing an internship, is there a requirement of certain number of days or hour after which CPT, you can't work under CPT anymore?
I don't understand the question exactly.
Let me try to rephrase the question if I can.
Yeah, I
can email you.
We've seen people use lots and lots and lots of CPT.
Okay.
Lots of it. Some people do CPT in 1 year program, then they move to another year program and use CPT again. Some people do 2 master's degrees and they use CPT after they've already used OPT. There's not a usually you're not going to bump into a limit on curricular practical training because they'll just authorize it and authorize it and authorize it. I've seen them authorize a full 2 years on a master's degree program. They authorize CPT for the entire time because it was an experiential based program, right? But that particular school had that policy Not every school has that policy. Not every school is going to authorize that amount. And just because there isn't a rule against it doesn't mean the school has to do it. Right? So if you want to be able to use optional practical training, you stay under a year. If you've already used your optional practical training and you're in a second degree at the same level, then you're going to bump up against whatever the school's policy is.
Okay, thank you. That was my question.
Is that
Yeah.
what you were asking? Okay, good. I hate when I can't catch the question. All right. So the next step for most people after you've done your qualifying STEM degree is H-1B. We have a quick slide here talking about travel. So F1 student travel, if you already have a visa stamp in your passport that's valid for the whole period of travel, and you already have an I-20 from your DSO that's endorsed for travel, travel's not so risky. But if you have a visa that's already expired, that means that you're going to have to go outside the country, get a consular appointment, and prove to the consular officer, again, that you have no immigrant intent to stay in the US. You're going to have to get that appointment in the time of COVID, which takes a long time right now, and you have to prove that non-immigrant intent. So anytime that you do that, there's a risk of not being granted a new visa. So it's risky, right? Travel as a student is risky whenever you have to apply for a visa. If you're in the middle of your optional practical training, it becomes even a little bit more risky. And the reason for that is that they know that you've already completed your studies. And so it's not as important to them that you get to return, right, to these consular officers. They don't see it as a big risk for you. The other piece is they may see that you already have an H-1B petition pending. And H-1B is considered a dual intent. It's considered a visa that people have immigrant intent with. So you have situations where some consular officers see all of that going on and say, no, you have immigrant intent, and they deny the visa. So there are risks involved, and it's important to understand that there are risks involved. The least risk that you can have is if you already have all of these items approved. You already have an endorsed I-20, you already have a valid visa, you have an employment authorization document that's already approved, and you have an employer letter saying, hey, this person left for vacation, they're just coming back to work for me again. Those things make it very little risk to travel. But if any one of those pieces fall off, your risk starts to increase. So it's important to understand and calculate the amount of risk that you're willing to take on when you travel. The second thing is if we go to this next step that I'm going to talk about in just a second, and you have an H-1B petition that is pending with U.S. Citizenship and Immigration Services, if travel's not recommended at that point, because again, they can see in the system that you have an immigrant intent type visa that's pending. So that may make them either not let you into the US in F1 status, or it might make them deny a visa. It also, if you've left the US after the H-1B petition was filed, but before it was approved, then what'll happen is that they'll deny the change of status to your H-1B visa. So they can approve your H-1B visa, but even if you come back to the US, in order to activate the H-1B visa, you would have to leave the US, apply for a new H-1B visa, and then come back to the US. So if you have an H-1B petition pending while you're in F1 status, not a good idea to travel until it's already approved. That way you can time everything out appropriately and plan your travel appropriately and not get stuck in a position where you're going to have to take extra trips. Really important that whoever the attorney is that's handling that H-1B at that point, that you contact them about travel before you do it. So any kind of travel that you're planning when you're changing status, extending status, doing any of those things, super important to get some good advice before you leave. All right, so H-1B. H-1B, again, is the specialty occupation visa. It's what college graduates use the most often because any country national, any national of any country can apply for this visa type. It's specifically made for people who have bachelor's degrees or higher and have jobs that are in specialty occupations designed for them. It allows you up to 6 years of H-1B status. They can give that to you in 3-year increments, and that's the highest number. If you have an employer who decided that they're only going to apply for 1 year for you, it's not a big deal. They're going to have to apply for a renewal faster, but you're still entitled to that full 6 years. The scope of your H-1B is that whoever sponsors that H-1B, that's the employer who's going to be listed on it. And that's the only employer that you can work for while you have an approved H-1B. That employer had to file that petition. They had to document your qualifications and that the job qualified. They had to pay all of the fees, and thus that is limited to work authorization for you. When you file that H-1B petition, when they file that H-1B petition, they file and provide specific information on their company, their ability to pay you, and the information about the job. So you're only allowed to work for that employer in the specific position that was listed on your H-1B petition. If you find another employer that you want to transfer to, or you want to work for 2 employers at the same time, the second employer has to file their own H-1B petition. And that does have to be submitted to U.S. Citizenship and Immigration Services on your behalf. They do have a nice little provision where it's called a portability provision, which allows you to start working for the new employer as soon as the petition is filed. So you don't have to wait for it to be approved, because immigration takes a long time to approve things much of the time. So you're allowed to start working for the new employer at the time that the petition is filed. But it does have to be filed, and you do need proof that it was filed so that you know that you're not doing anything wrong. Because again, they're the ones filing all of it, but you're the one who has all of this responsibility for keeping your status. With H-1B, yes.
I'm sorry, can I ask, can you go back to the previous slide? So this approval without, they can start the new job, right? Okay, so what is the circumstance is there a circumstance where it might not be approved, and then what happens?
So there are circumstances where it could not be approved. If they have a good attorney, the attorney's not going to file it if it's not going to be approved. Okay. These are pretty certain situations. If you have an attorney who's filed 500 of these, they know pretty much whether or not it's going to be approved when they look at it, right? If it turns out that they were wrong, then there are 2 options. You either can go back to the other employer, the old employer, if that employer has not revoked your petition, or you can have someone file a new one. So this is really, really minutia, but sometimes what the employer will do who got theirs denied, they'll just refile a new one. Or your old employer will refile a new one. There's like a 30-day grace period between employers, 30 to 60 days where you can, try to file something new. All of these are going to be really personalized situations. Some people demand premium processing for just that reason. They're afraid of that denial. So they ask for the new employer to pay for premium processing so that they can have an approval before they switch employers. A lot of employers are not going to do that because that's an extra it costs an employer about $5,000 to file one of these much of the time. And it's an extra $2,500 to file for premium processing, only to have some employees just decide that they're not going to join after you've paid $7,500 to file their immigration paperwork. So there are a lot of employers who aren't going to do that. And so you have to depend on this portability and make sure that the employer is somebody that you see as reputable, so that you're pretty sure that their petition is going to get approved. It is a limbo moment, but always keep in mind that you can have your own attorney kind of help you if something like that happens. So if your attorney, your employer's attorney gets a denied petition, and then you need advice on how to help yourself after that, you can contact your own attorney to try to get advice on that if they're not able to advise you. Great. All of that to say, all of that is a long-winded way of saying it will be fine. There are ways to fix it. You just have to make sure you get good advice after it's happened. All right, so the H-1B issues, like we were talking about, the employer has to pay all of these fees. They're responsible for all of them. They cannot ask their employee to pay them. They can't ask the employee to reimburse them. All of the fees that you see on your screen are required employer fees. If you find an advertisement in the newspaper that says, we're hiring H-1B employees, here's your recruiting fee for you to pay for it, or if you get involved with an employer who wants you to pay for the fees or reimburse for the fees or authorize for direct deposit withdrawals, right, for the fees, it's a scam. It's not a reputable employer, and I know how everybody wants to be able to find a job quickly, but that's not the job for you, because if they're trying to do that, then it's not a reputable company. There's been a couple of situations recently where the Department of Homeland Security has run sting operations where they placed advertisements like that in the newspaper. and actually ensnared some students who applied for the jobs and then were willing to pay those fees and such. And then, I mean, basically the students were entrapped into it because they were looking for positions, and the Department of Homeland Security put in something that was unlawful and the students pursued it. So it's just really important to keep in mind that if you see something like that advertised, it's not real, it's a scam. It could actually be a company that is predatory who is trying to scam you. Or it could be the Department of Homeland Security trying to scam you. Either way, you don't want to be involved in it. All right, so the problem with H-1B, right? We've just talked about that the employers have to pay for it. So they now have skin in the game. This is something that they have to do. Well, if that employer has already worked with you through your OPT and your STEM OPT, or just through your OPT, and they know that you're a great employee and they want to keep you, these fees aren't a big problem, right? For them, it's an investment because they know that you're a good employee. They know that they want to have you. They know that they need your skills. They're willing to pay these fees. The bigger problem is that there are a lot more people who want these visas than there are visas available. So every year, the government has its fiscal year starting in October. It runs through September. There are visas available every October through September. The law allows employers to apply 6 months ahead of time. So here we are in January. We're approaching April. The lottery is going to be run in March for these positions. Why? There are 85,000 slots available. And last year, there were more than 350,000 people who applied for those 85,000 slots. Okay, so what happens is that they get all of these entrants, and then they have to find a way to select the entries that they're going to allow to have H-1B visas. So what they do is they run a lottery. 20,000 slots are reserved for advanced degree applicants. So these are people who have US master's degrees or higher. And then there are 65,000 slots for people who have any kind of bachelor's degree or higher. So if you look at this little calendar here, you have to keep in mind, I guess the majority of people kind of graduating in this May period of time. The H-1B petition doesn't start until October over here. You have to actually enter all the way over here in March, right? So if let's say that you've had an employer who you've done some CPT for, and that you're graduating in May, that employer knows that they want to hire you, they could conceivably go ahead and sponsor you in March. They could go ahead and enter you in the lottery, knowing that in May, you're going to have your OPT and you'll have a full year of work authorization. This is the first chance that they have where they can sponsor you. Typically, the dates that they allow this opening is that first 2 to 3 weeks of March. And then once they have the entries, they always say they're going to select by April 1st, but the weekend before April 1st, they typically start sending out notifications of people who are going to get to enter. The petition itself has to be filed within 90 days of lottery selection. So first scenario, let's say that you're graduating in May and you know you're going to have OPT, but your employer knows they want to sponsor you. That's totally fine, as long as the degree is conferred before you have to file. So they enter you in March, it's selected in April, you graduate in May. That means that it's only a 60-day period, you'll have that degree, and they'll be able to file your full petition. The second scenario, let's say that you graduated in May, started working for your OPT employer, and you have work authorization from this May to next May. Well, the next lottery entry is going to be over here in March. So if you are working for this company starting in May, about January the 1st, you want to start talking to that employer about whether or not they're going to be willing to sponsor for H-1B. And you want to start talking to them about what that procedure looks like, about that lottery, right? So if that happens, now you're entering in March and filing after an April 1 selection, knowing that you only have OPT through May or June or July, depending on what date you selected. Keeping in mind, as long as you're going to have either your advanced degree or your bachelor's degree by the time that the petition is filed, you're going to be able to enter based on whatever selection you're going to have within that period of time. So if you're graduating with a master's degree, you can apply in the advanced degree, even if you don't have it at the time of the lottery, but you will have it at the time of the filing. So if you have that OPT, we were just talking about an OPT through May of the following year, but you're entering in this year's lottery. If you have OPT and you're selected in the lottery and you file, before your OPT expires, then your I-20 will automatically update in CVIS to give you work authorization through the beginning of the fiscal year. So let's say that you chose May or June or July for your expiration date. If you get selected in the lottery and you file before that date, you'll have work authorization through September the 30th, called cap gap relief, so that you don't have a lapse in your work authorization. Now, a lot of people who have STEM OPT, I'm assuming that some of us have STEM OPT, a lot of people go ahead and apply every single year because you're not guaranteed to get selected any year that you apply. And the more times that you get to enter, the more likely you are, the more bites of the apple, right? So if your employer is willing to sponsor you before you graduate, awesome. Have them do that. Ask them to do that. If you're a STEM graduate and you have 36 months of work authorization, but your employer is willing to enter you on the first year, take advantage of that. Don't waste that year because you could get selected in the very first year that you apply. All right. Do we have any questions about the H-1B lottery so far? We don't have any questions in the chat. All right, so what we've been talking about so far is the H-1B lottery. That lottery applies to all for-profit employers in the United States, which is the majority of sponsoring employers. That cap, that 85,000, is how many new H-1B visas that they can be granted each year. Important to note that each employer can only sponsor each employee for one position. But what we believe is happening is that some students and some applicants are getting more than one employer to sponsor them. That is allowed. So if you had a CPT employer who really, really liked you and wanted to sponsor you for H-1B, and you also had an OPT employer who wanted to sponsor you, each of those employers could file a lottery entry on your behalf, and that's totally allowed. But your OPT employer can't sponsor you for more than one position. They can only do one single lottery entry for you. They do have a computer detection system. If they detect more than one entry for the same employee from the same employer, they will kick you completely out of the lottery. So it's really, really important to keep that in mind. Now, there are some employers who are exempt from this requirement. Those are called cap exempt employers. The classifications you see on your screen are cap exempt employers. What that means is they are not subject to the H-1B lottery in any way, size, shape, or form. They can file as many H-1B petitions as they want a year. They can do it any time of the year. They can file it for any positions that qualify. They're unlimited. Okay, so universities, nonprofit organizations that are affiliated with universities, nonprofit research organizations, and governmental research organizations. These are cap exempt entities, and you would be actually absolutely shocked and amazed how many employers these are. So just think about in your own area, the hospital systems that are affiliated with universities and medical schools and nursing schools. Think about all of the public and private schools that are affiliated with universities for their teaching programs. Think about research organizations where it's a nonprofit that's doing homelessness research or environmental research or traffic research. There are all sorts of different organizations that are cap exempt, some of which know all about it and some of which don't. There's not a list, a comprehensive list online. It's harder than that. If you're trying to find a cap exempt employer, or if you're trying to figure out if an employer who's offered you a position is cap exempt, you have to look a little bit more deeply into what it is that they do. So if you're working for a university, you know that's going to be a cap exempt position. That is specifically, that's any position. It's not just professors, it's people who work in administration, people who work in research and accounting and all of those different parts of the organization that would require positions that hold positions for employees who hold bachelor's degree. They're allowed to apply for all of those positions. Any of those positions they can sponsor for. It's the same thing when you're talking about a hospital that's nonprofit and affiliated with a university. It's not just the physicians or the nurses. It could be people who are in the finance department. It could be people who are doing research within the organization. So if you find an employer who's a nonprofit, and they want to sponsor you, it would be a good idea to try to figure out if they might be affiliated with a university or they might be a designated research organization. And then you would not have to worry about that H-1B cap or the timeline that we just discussed. It's important to note, the next question that I always get people asking is, well, once I get a cap exempt employer, couldn't I transfer over to another? No. H-1B approvals are limited to the employer. So if you're working for a cap exempt organization and you want to work at the same time for a cap subject employer, and that's what we call those for-profit entities, you can have what's called a concurrent H-1B. So you could be working for a university and then also working for a for-profit employer. But as soon as the nonprofit work ends, so does the H-1B authorization for the for-profit entity. So it's just really important to understand that you can't flip-flop back and forth between the two if your only approval is a cap exempt entity. If you have a cap subject entity and you want to switch to a cap exempt, that's totally fine. But you can't do the reverse because they're not going to just let you loophole your way through the cap lottery. Okay. All right. So that is our H-1B visas. There are alternatives to this, and this is some of the attachments that I sent in the reading materials. If you are a passport holder for Canada, Mexico, Chile, Singapore, or Australia, these are countries that have a set designated number of visas or types of visas that are specific to nationals of those countries and are very, very, very similar to the H-1B visa. So if you are from one of those countries, you could qualify without regard to the cap for a different kind of visa that's very similar to H-1B. Those are listed in the materials. The other alternative type is an L1 manager, executive, or specialized knowledge individual. These aren't typically for new graduates, and that's because these are intercompany transferee positions. So let's say that you work for a multinational organization abroad, and you've worked for them for a year, and now they want to transfer you to the US for one of these types of visas. That would be an L1 visa, and that would be something that you could qualify for as a college graduate. E-treaty investors or traders, it's another type of visa that's detailed in those materials that I sent over. Those are only for people who are nationals of countries who are parties to the visa. So if you hold a Chinese passport or an Indian passport, those are not parties to those treaties, and so they would not qualify for these e-visas. A lot of people, if they don't get selected the first time in the H-1B lottery and they don't have a cap exempt employer and they don't qualify for these other visa types that you see up top, some of those people re-enroll in F1 or they find a J1 sponsor who's willing to sponsor them to continue working in the US. Some other options are listed in your paperwork, thinking of O1, Q1. O1 is specifically for tippy top of your field. So it's typically people who have years of experience, publications, international awards, those types of things. It's really, sometimes you'll hear on the news, those called like the Einstein visas, right? For people who have really a tip-top qualification. Now we're going to get really quickly into green card paths. And you may have seen on the news people who are arguing against immigration where they act like there's a lot of ways to come to the United States on sponsorships. It's really, really limited. This is not as easy as it sounds, and it's really time consuming and expensive. Family relationships are super limited. If you marry a US citizen or a green card holder, those people can sponsor you very quickly. If your parent is, if you're under 21 and your parent is a US citizen or a lawful permanent resident, they can typically sponsor you very quickly. If you yourself have a child who's over the age of 21, that person can sponsor you very quickly. Those are all classifications that are considered immediate relatives. But once you hit 21 years old, if your parents are sponsoring you, that's a classification that's going to take 5, 6, 7, 8 years to be current. If you have a sibling who sponsors you, it's going to take more than a decade for that person's visa to become current. Right now, it's taking 15 or more years. And that's because every single year, just like the H-1B lottery, the government limits the number of green cards that can be given out based on a family relationship. They don't limit it for those immediate relatives that I was talking about. So they don't limit it for spouses of US citizens. They don't limit it for parents of US citizens, and they don't limit it for children under the age of 21. but every other classification is number limited, and every year the backlog grows. So every year the wait gets longer. When the immigrant petition is filed by your family member, that's when your space in line is established. And that's when your priority date is established. So you can go online and look at what's called the US Visa Bulletin and see all of the classifications and how long they're taking right now, but understand that every year the wait gets longer. There's also something called the diversity lottery. US students are allowed to apply for the diversity lottery if you're from a country that is underrepresented in green cards to the United States. If you get to the point where you have been selected and you need to apply for the green card step, that's when you would need to talk to an immigration attorney to figure out how to get it done properly. And I would definitely recommend on making that consultation. Employment-based green cards are, again, there are 5 classifications. We're going to focus on the first 3. There's some information in your packet about the others. EB1, again, is that Einstein-y type of visa. It's where you have somebody who is extraordinary or outstanding in their field. It could be a university professor who's just really, really well-known, well-versed, big research publisher, has lots of awards. Or it could be a multinational executive. So on the last slide, we talked about those L1 visas where you've worked abroad for a multinational and they want to bring you to the US. They can sponsor you for that L1 visa, but they can also sponsor you for an EB1 green card. EB2 and EB3 is where most people live when they apply for the green card. And those are typically what's called the PERM process. It's a really long, involved process. It's currently taking around 2 years for anybody who's not born in China or India. And those cause you to actually have to apply through the US Department of Labor. So what happens is an employer files what's called a prevailing wage. They say to the Department of Labor, I have this person I want to hire. Here are the qualifications for the job. Tell me how much I would have to pay them. That goes through the Department of Labor. The Department of Labor issues a finding. And then your employer has to advertise your position and prove that they can't find any competent US workers who are minimally qualified for the job. That, again, that process takes around 2 years to complete, and they have to finalize all of these steps before you're allowed to file your immigrant petition with the US Citizenship and Immigration Services. These are also subject to number limits. You can see the number limits in the visa bulletin every single month. And if you're not from China or India, then you'll probably be eligible to file your last step, your green card application, super quick after the immigrant petition is filed. If you're from China or India, then you have to worry about really big backlogs because there's so many applicants from China and India. At that point, what you'll need is you'll have to have an underlying non-immigrant visa. Remember, we talked about that H-1B, we talked about the L. If you have an H-1B visa and you have a green card process started, they'll allow you to extend your green card to wait on to extend your H-1B to allow the green card to process. Do we have any questions here at this point?
I have one question, but it was like something that you mentioned a while back. So we, after graduation, we still have to go back to our country to get a new visa since our F1 would have expired and we need the H-1B visa actually to remain in the United States.
So a lot of people have that misconception. When you're in the United States, your stay is authorized by your I-20. The visa stamp in your passport is only required if you have to travel. So the visa stamp, you use it to enter the US when it's valid, and then it's irrelevant to you until you have to travel again. What happens is every time that you need to extend your stay or you need to apply for something new, there's a process for that. So your DSO continues to update your CVIS record. Your CVIS record governs how long you can stay. It gives you extensions on your stay. When you get your optional practical training, it'll have an end date on it. At the end of that, you either change status, like we talked about, to H-1B or another visa status, or you re-enroll in school. If you re-enroll in school, then your status is still governed by your CVIS record. If you file an H-1B petition, if your employer files an H-1B petition, it'll be issued with a new I-94 at the bottom of it. Just like what you were issued at the border, only on this special USCIS paper. So that would govern your stay while you were in the US. If there was a reason that you wanted to travel, then you leave the US and you do have to apply for a new visa. But the visa expiring while you're here means nothing to you. That actual visa stamp that's in your passport, you don't care about that until you actually want to travel again. Good. Okay. Any other questions? All right. So it's super important to understand a couple of things about immigration representation that I just want to get out at the end. When an employer has an attorney file a petition for you, that attorney will make clear whether or not they also represent you. Every attorney is different. If they have agreed to represent both of you, it's what's called a dual representation. And in that dual representation, they have to represent both of your interests in the filing. Meaning, if you share information with them, then they would be compelled to share that information with your employer. So if you have information that you do not want shared between your employer and the attorney, then you would need to find your own private attorney for that part of your process. If the attorney at the very beginning tells you, I represent your employer, I don't represent you, it's much the same. You wouldn't share any information with that attorney that you don't want your employer to know. And if you have questions about your process at that point, you would contact another attorney to help you with the advice you need to understand that process. So it's just super important that you understand representation. You need to assess at the very beginning whether or not that attorney represents you and the employer or just the employer, and assess whether or not you can ask questions without it going back to your employer. If it's a question you don't want your employer to know about, you need your own attorney. Immigration law is super broad. There are lots and lots and lots of subspecialties within immigration law. For instance, I work with international students, I work with employers, I work with family-based cases. If you contacted me for an asylum case, I have a whole list of attorneys. That's immigration law, right? But I refer you to an attorney who specializes in that particular field of immigration law. There are people who need inadmissibility waivers. There are people who are in removal proceedings. Those aren't things that I do, but I have a list of attorneys who do that I know are super good, and I refer to them. So it's really important that when you decide to hire an attorney, that you do it with good research behind you. You can go to websites like the American Immigration Lawyers Association and research the specialties of the attorney, and make sure that you're hiring somebody who specializes in the type of immigration that you're looking at. So if you're looking at a family-based case, you want somebody who actually handles a lot of family-based cases. If you're doing an employment-based case, you want somebody who handles a lot of those cases. And if you're in removal proceedings, you don't want an employment-based attorney. You want a removal attorney. So all of these things are super important, super broad. American Immigration Lawyers Association is a good place to look, or you contact another attorney that you trust because they'll have a list of people that they can refer you to that they know have performed well in the past. Location is irrelevant in most cases because immigration law is federal. So if you are living in California and you want to hire an attorney who is in Idaho, you can do that. You're totally allowed. The only time where location would be relevant is if you were in removal proceedings and they had to attend court in the location that you're at. So that's the one time that immigration law is local. The rest of it, it's federal. You can hire somebody anywhere you want. All right, with that, I know that I have exceeded my time, but I'm happy to answer questions. If anybody is remaining that would like to ask questions, feel free to type them or to just ask them on the screen.
Well, that was a lot of information to take in. So yes, certainly feel free to ask any questions you may have right now. But I hope you all took down Crystal's email address for reference. And I'm sure maybe along the way you will have this to reference, okay? You have your packet that I sent to you, as well as Crystal's email. So hopefully all of those resources pulled together can help answer your questions. But really appreciate everybody joining us today, and thank you especially to Crystal. I really appreciate you taking the time to help our students with this really difficult process. So if we're all set with questions, sounds like Monica does, so go for it.
I have one question. I don't know if you already mentioned this, you probably have, it was just a lot to process. So I'm a senior right now, and I'm going to graduate in May. And so if I apply, can I apply for OPT right now? Like, can I go to the registrar and talk about applying for OPT right now? And how
So
long does it take for OPT to, once I apply, to actually get approved?
Yeah, so they have their own procedures. I would definitely contact them to see what their internals are for how you contact them and how you handle that process. You're a tiny bit early, but they probably want to know who's getting ready to apply so that they can give you all of the necessary information. But you wouldn't apply quite yet because you're not within that period of time before graduation day, right? So you have to make sure that you meet all of the requirements that were on the screen because you're going to be applying now. So these are the current requirements. 90 days before completion of the program or up to 60 days post completion, right? You have to contact them. You have to get your OPT authorized. And you have to make that application within these time periods, right? They have a goal of under 90 days for adjudication. We have seen some outliers that are taking up to 6 months for these applications. So just understand that they can take longer, but they are really trying to get it down to 2 to 3 months.
Okay. Okay, thank you.
Yeah.
Anybody else? Okay. All right, well, we'll conclude this and thank you, Crystal, and expect this in your inbox along with, the packet that you have. So thanks everybody and have a great night.
Same to you guys. Thank you so much for coming.
Thank you.
Thank you.